Hey, what's up, everybody? Just want to go over the big news here in San Diego County. It's sort of the shot heard around the world right now in terms of COVID restrictions here in California. I've heard some other people from other parts of the country who've heard about this big news and what this means. It came out late last night, and it was kind of breaking news last night. So a lot of people, a lot of restaurant owners are waking up to some great news this morning. A minute order issued by the Honorable Joel R. Woolfield. I hope I said his name right. Sorry, Your Honor, if I got that wrong. But this is in the Superior Court of California County of San Diego. So this is dealing with just San Diego, not all of California. But this is a big deal for San Diego in general. What happened was there was a application for what is called a preliminary injunction. Now, a preliminary injunction is usually requested at the beginning of a case when there is some harm being done to somebody and they can't wait until trial gets completed to stop that person from being harmed. And the reason for that is because trials can take a long time. There's discovery. They could be a year out, maybe 2 years out. So if you were to allow the defendants to basically continue harming the plaintiff, by the time they got to trial, they might be so irreparably harmed. And that's usually the key word, is irreparably harmed, to the point where they can't, it doesn't even make sense for them to go to trial anymore, because the matter is kind of moot at that point. And that's certainly the case here in California with a lot of these restaurants. And here in San Diego, is a lot of these restaurants were shut down under these new lockdown orders, under these new regions and ICU capacity and the purple tier, and everything gets so confusing. Restaurants were thus shut down for only takeout or delivery. So no more outdoor dining, none of that at all. It's just takeout and delivery at this point. I want to go over the minute order because I think it has some great nuggets to move forward with. And this is one of those things that if you're an attorney who follows this, like I am, there's a lot of good stuff in here. There's a lot of good stuff if you're fighting these cases that you can take with you into subsequent cases. And this is the second court now, and the second judge to bring up and strike down a county's orders to shut down restaurant operation for the same reason, which is that the government has not provided enough evidence to show that it's necessary to have these lockdowns when they can't produce enough evidence to show why. So we're going to get into it a little bit and talk about, highlighted some stuff for you. Like I said, Honorable Joel R. Woolfield, Midway Venture LLC versus the County of San Diego. I think it also goes up against the state as well. The order to show cause, these are just register of actions, for a preliminary injunction by plaintiffs Midway Venture LLC, DBA, so this is Pacers. Pacers is a strip club. And remember, recently, strip clubs were exempt under a lot of the lockdowns because of the First Amendment. Now they were shut down again based on the new restrictions. It's against the defendants of County of San Diego, William Wooten, who is our public health advisor, Dr. William Wooten, in her official capacity, Governor Gavin Newsom. So it's going up against Gavin Newsom as well, and the California Department of Public Health. And it is granted. Pending the trial of the case, defendants, each of them and their respective agents and assigns, and any governmental entity or law enforcement officer are hereby enjoined from enforcing the provisions of the cease and desist order or any related orders, including the state's regional stay-at-home order that prevent plaintiffs from providing live adult entertainment. And this is the big one. This was the big shock that everyone got. San Diego County businesses with restaurant service, such as plaintiffs' establishments, from continuing to operate their respective businesses subject to protocols that are no greater than is essential to further defendants' response to control the spread of COVID. So what does that mean? That means during this entire time, they might appeal it. I think they're looking into appealing it already. Where that goes, I don't know if they'll stay the order or anything like that. This is just coming out last night, so it's hard to figure that out. But what does that mean? It means the county and the state right now, because the state was also a defendant, they are enjoined, meaning they are prevented from stopping any restaurant from reopening in San Diego County. That's big for San Diego County restaurants. I mean, you have no fear that there's going to be someone who shows up with a cease and desist letter. There's not going to be a sheriff who shows up because they have been enjoined by enforcing these lockdown orders. So if you're a San Diego County restaurant owner, today is a great day. Christmas came early. You got a week early. You got a big old Christmas present. And you can reopen. Now what that means, and this is sort of the last line, subject to protocols that are no greater than is essential to further defendants' response to control spread of COVID. I don't know why I said it like that, but whatever. what that means to me, if I'm reading that, and if I'm advising you as a restaurant client, is that you could probably go back to outdoor dining and indoor dining that was masking, limiting capacity, and as well as just keeping people distant from each other. That doesn't mean it's a free for all. It doesn't mean you can just open up and do whatever the heck you want now. It means you still have to abide by the guidelines that were in place before, but it just means you can now reopen outdoor and indoor. And that was sort of the big question. People are trying to find clarity on it. That's how I would read it, is that they're trying to say, well, can I open outdoor? Can I open indoor? I would say for the time being, you could probably open indoor and outdoor until there's more clarification, but still make sure people are masked up, make sure that you have the tables spread apart, that's limited capacity, stuff like that, but you can still open indoor and outdoor. Now on to the legal stuff. There's a lot of stuff they get into, register of actions, and the evidence that was produced. This is a lot about what they wanted for the strip clubs. We're not really going to talk about the strip clubs. I want to talk about the restaurants because I think that's a huge sector of our economy here in San Diego that has been absolutely killed and being used as a scapegoat. Facing financial ruin, plaintiffs have filed this action to contest Dr. Wooten's cease and desist letter or any related orders which prevent them from continuing to operate their respective businesses. That's basically what they got. The testimony of Shamshon Bunanti, I can't say that name, are consistent with the opinion and testimony of Dr. Lawrence Meyer, who states at paragraph 3 of his declaration, I've been asked to opine on the issue of whether a restaurant would increase the risk of its patrons or employees if a dancer performing on stage were present if the danger is 15 feet away from all patrons, and suitably matched. There's no scientific evidence of increased risk to the patrons if dancing is allowed at a restaurant under those conditions. And then they kind of go into this and they hammer them on this. Defendants have not submitted any evidence to refute the testimony of Shamshon. I hope I'm probably butchering that name. And these other people who made declarations. The court infers that based on the declaration upon us, the county possesses contact tracing data and has the power to produce such evidence to refute plaintiffs' assertions that plaintiffs provide live and adult entertainment and San Diego County businesses with restaurant service, such as plaintiffs' establishments, subjects to protocol, do not present any risk, much less a greater risk than before Governor Newsom issued a December 3rd, 2020 regional stay-at-home order. So basically what they're saying is you as the county, and this is really huge, and this is one thing that a lot of us attorneys have been fighting, is show us the data. And we saw the same thing in LA, which was show us the data. If you think that there is a widespread and it's happening at restaurants, show us the data. Just show us the data, show us the science. If that's what we're believing in, we got to believe the science and the data. You should have it. You should have this all in front of you. You should be able to produce in a court of law. It shouldn't be a big deal. This judge is basically saying you failed to provide any evidence to show, and there's plenty of declarations to show that it doesn't spread and that there isn't a substantial increased risk if you're at a restaurant. So this is why they got hammered. This goes on to some more stuff. Talking about injunctive relief, and it goes into some case law. A lot of people are trying to say that because it was changed and whatever, that they tried to do the same thing with a Supreme Court case that we talked about, Gorsuch, is that it just because they change it doesn't mean they're not under threat of changing it again. And because Governor Newsom changes everything kind of every 3 weeks or every month, then there needs to be a court order to prevent them from doing anything again. Just because you stop doing something doesn't mean you can't be enjoined from doing it again. The applicants have made the showing needed to obtain relief, and there is no reason why they should bear the risk of suffering further irreparable harm in the event of another reclassification. Going down. Nobody is in a better, more informed position to manage the local health conditions than Dr. Wooten. With full knowledge of current data, Dr. Wooten has purportedly represented that, and this is big, she herself said that penalizing sectors like restaurants and gyms for the case increase is wrong. Closure of indoor restaurants during wintertime will move people into homes and encourage high-risk gatherings. Closing indoor capability contradicts the blueprint for a safer economy. Further, the county has taken steps to complete outbreak assessments, enforce compliance, and to educate and engage the community. So, Dr. Wooten herself has said this isn't the best way to do it, that she hasn't seen the data and the numbers. It sounds like she's just kind of followed marching orders from Sacramento. But she herself kind of put herself in a position where she said, I don't believe that there's any big risk from restaurants and gyms. The court infers from Dr. Wooten's purported representations that she does not consider businesses with restaurant service, such as the plaintiffs, to be responsible for the increase of the county's COVID cases. So she herself said that she doesn't believe that that's something that causes a spread. And it goes on to repeat her again. And then it talks about what public interest is. And this is the Roman Catholic Diocese of Brooklyn versus Cuomo. This was a recent case. Public interest, finally, it has not been shown that granting applications will harm the public. As noted, the state has not claimed the attendance of applicant service as resulted in the spread of the disease. And the state has not shown that public health would be imperiled if less restrictive measures were imposed. Members of this court are not public health experts, which they've been saying all along, and we should respect the judgment of those put special expertise and responsibility in this area. And this is a quote from Gorsuch, but even in a pandemic, the Constitution cannot be put away and forgotten, emphasis added by the court. Whenever the court emphasizes anything, that's a big, big deal to look at. They talk about what Justice Gorsuch said, and I knew that the Justice Gorsuch opinion in that case, the Church of Lukumi, Babalu Avenue, was going to have widespreading repercussions for the rest of the country. So good on Justice Gorsuch to lay down that groundwork. Goes on to say businesses with restaurant service, such as plaintiff's establishments, serve the public interest. These business establishments provide sustenance to and enliven the spirits of the community, while providing employers and employees with means to put food on the table and secure shelter, clothing, medical care, education, of course, peace of mind for they and their families. However, as Justice Gorsuch noted in his concurring opinion, and this is talking about Jacobs v. Massachusetts, I've talked about this before. It's an old case that the state relies on all the time. Government has been relying on it to say, emergency powers are plenary, we can do whatever the heck we want. Gorsuch didn't agree with that. That decision involved an entirely different mode of analysis, an entirely different right, an entirely different kind of restriction. So let's keep jumping down. This was pretty big too. The court didn't actually go as far as including all these businesses, but it did send out sort of one of these legal warnings, I think. It talked about how a wide array of businesses and other activities, including gyms, fitness centers, yoga studios, a whole bunch of other things, restaurants, spas, fraternities, sororities, religious entities, and entertainment centers, does little, if anything, to demonstrate any nexus between businesses with restaurant service, such as the plaintiffs who've implemented protocols is directed by the county, and the spread of COVID. So basically they're saying all these things, gyms, spas, all this stuff that didn't contribute in large numbers to COVID cases are being punished. And this is good case law precedent. This is good precedent for any business going forward, like a gym. And I know the gyms are fighting it right now. They didn't win their temporary restraining order, but this time this judge actually did grant it. Remember, there's all different judges here, different things. And sometimes you just get a luck of the draw when it comes to judges. This is really crucial, though. When I heard that they granted the preliminary injunction, me as an attorney, I sat there and said, that's really good news. Because when you grant a preliminary injunction, there's two things you have to consider as a judge, as the court has to do. And it's these two factors: the likelihood that the party seeking the injunction will ultimately prevail on the merits of his or her claim, and the balance of harm presented, the comparative consequences of the issuance and non-issuance of the injunction. Basically, what the court is saying here is, we know that if we don't grant this, the plaintiffs are going to be irreparably harmed because their businesses will be shut down for a long period, losing lots of money. They might even shut down permanently. Also, it means that they believe that there is a good chance they're going to win on the merits. So that's a sign from the judge right now saying they believe in this case and they believe that there's a good chance that they're going to win this case. So when you win a preliminary injunction, that's huge because it gives you the faith that the judge is kind of already on your side and believes that you're going to win. Now, things could happen, trial could happen, more evidence can come out, but regardless, it does show that the judge and the court in this case does believe there is a really strong case for the plaintiffs. Plaintiffs have made adequate showing that they've exhausted their capital trying to comply with defendants' endless and bewildering orders, have sustained significant, if not draconian, losses, and are fearful that their businesses may be closed permanently if defendants' latest orders are not enjoined. That's part of that irreparable harm. So it finishes off by saying that the reason they granted it, that the harm to plaintiffs would be greater than the harm to the defendants, and it is likely that the plaintiffs will prevail on the merits of one or more of the claims. That's huge. That means that we're already, while this is enjoined, there's a good chance they'll win in court down the line. Finally, the court emphasized that the reach of preliminary injunction is limited to plaintiffs providing live adult entertainment, and this was the shocker, any business with restaurant service. So, That's what the preliminary injunction is talking about. Although it mentioned gyms and spas and all these other things, that's really not what the case is, because the plaintiffs are adult entertainment. They're strip clubs with restaurant service, but they also threw in the whole restaurant industry because they are classified as that as well. So, takeaway for you: if you are a restaurant owner in San Diego County, you can open today. And like I said, still abide by the COVID guidelines. This doesn't mean it's a free-for-all. It doesn't mean you can just go do whatever you want. You still have to abide by what were previous COVID guidelines. Now, I'm sure going from just takeout and delivery back to indoor and outdoor limited capacity is better than nothing. It's not a slam dunk. You don't get to reopen as you want, like full capacity. But it does allow you to at least have the dine-in service of indoor and outdoor. Obviously, have your staff keep wearing the masks, distance the tables, keep people separated, limit your capacity, and you're good to go. But in the meantime, the county cannot. They said they're not going to, because it was their decision. The court ordered them. They cannot enforce any of these lockdown restrictions. So the county in San Diego is not going to come in and do anything to you if you're a restaurant. So my advice to you would be, go ahead and open and enjoy this. Take this as a big win right ahead of the holidays. Hopefully it helps your business. And thanks for sticking with me. And that's your update on what's going on in San Diego County with the restaurants. All right, talk to you later.